person in custody, and by counsel Jennifer Cunha.
All right, are we chapter 950 compliant?
We are.
Now, before we get to the prelim, I noticed that there's two motions to dismiss that have been filed by the defense. First is at docket 9, the second is at docket 12. I reviewed both of them. I'll hear any further argument if there is any, and I'm, of course, I'll have to hear from the state, who has not had an opportunity to weigh in yet. Ms. Cunha.
Understood, Your Honor. And Your Honor, I agree that we can deal with both motions at once. The first motion is, it's our position that the state has not alleged an unequivocal act. The case law pretty clearly indicates that an unequivocal act is one from which it's the point of no return. The four corners of the complaint at least indicate that the defendant was in a car in the area of the home. Certainly, I will defer to the court's familiarity with cars, but it's my experience that they can be turned back on and turned around. We are certainly not at the point of no return based on that behavior.
Well, what would be the point of no return? Would getting out of the car and taking a step towards the house be the point of no return?
You know, Your Honor, had that happened, I might say.
But why couldn't he turn around, get back in the car, and drive away at that point?
It's
kind of a hard concept for me to wrap my head around, because the point of no return is right up until the very point where the act actually happens.
Certainly.
So what does that mean exactly?
Your Honor, I think given the crimes alleged here, and it's obviously the analysis is different with every crime, but given the crimes alleged here, particularly for the first four counts, I think the point of no return could look like getting to the house, could look like a number of hypothetical scenarios that we don't have here. Stepping out of the car certainly would be one further step along, but that's not what's alleged here. What's alleged here is he was parked on a public street in his car. The case law, and I think it was Barry, but please don't quote me on that, suggests, so there were a couple of cases that indicated things like there was a gentleman that approached somebody to shoot that person, and it turned out the gun didn't work. And so that was an appropriately charged attempt, according to, I believe, the Supreme Court at that point.
Is it up to me to decide whether it's the point of no return, or is it up to the jury to decide ultimately?
I think, Your Honor, that it's up to you to decide whether or not, as a matter of law, this is an unequivocal act. And if the court decides that it is not an unequivocal act, or there's some equivocation in the act, then I think, as a matter of law, then I think that is an appropriate exercise of the court's power. Should the court decide that there is at least enough there to, at this stage, find that there's probable cause that it could have been an unequivocal act, then I think it's a factual determination for the jury at that point.
So what I gather from you, you're saying obviously there's a spectrum, right?
Yeah.
So had he never left his house,
yes,
probably not an unequivocal act. As a matter of law, you're saying I could rule
yes.
under those circumstances. Had he broken into the house, certainly probably to decide. And then the question is everything in between. Where does that go from a matter of law, not an unequivocal act, to, well, we have to decide?
Yes.
And why is it that these circumstances are on that side of the spectrum as a matter of law?
Well, Your Honor, I think as a matter of law, we are dealing with a situation where, and this is where the second motion comes in, we're dealing with a situation where the allegation is that there are writings in a private journal that was hidden. That private journal contained, among other things, at least one other story about killing a family and himself. And that was alleged in, I think, page 7 of the complaint when EJS reaches out on Discord to try to find information to contact a person whose initials are TP. That was not deemed to be serious. So the reason that this, as a matter of law, isn't an attempted homicide or even an attempted sexual assault, as is alleged in the other two counts, is because the only difference is that writing, that private writing between the 22 CF 900 and this one. And I think the reason that these counts weren't charged initially is because there was enough equivocation in the allegations or the actions allegedly attributed to the to the defendant at that point to not merit those charges, to not merit an investigation until after the Post-it notes came to light, to not merit any of that. There was equivocation, and we know that from the four corners of the complaint, the procedural history of these cases, that as a matter of law, we simply don't have that point of no return, the attempted firing of a gun that turned out didn't work kind of thing. And had he gotten closer, I don't know what we would be arguing, but he was in his car, or that's what's alleged. He was in his car. It's not alleged that any firearms were found on his person. The allegation is he'd been sitting there long enough that a neighbor noticed and called the police. There's no allegation that he did come out of the car. There's no allegation that there was any contact made with the alleged victim or her family. There's no step that would indicate that the story that was written in the journal is any more threatening than the other stories written in the journal that law enforcement deemed not to be credible. So I think that's where we get to a matter of law.
Okay, and then for your First Amendment argument.
Your Honor, with that, very simply, I think, sort of for the reasons that we've already set forward, I think this case is more analogous to the Douglas D case than anything else. I think we've got something that was described in the complaint as an almost daily journal. It's got, as I mentioned, at least one other story about killing other people and himself. There is every indication that this was a piece of private writing. It was not found until about a week before, according to the complaint, before the law enforcement gathered the journal. There's no indication that the last couple of pages, which are referred to in the complaint, were addressed directly to CAR. There's no allegation that this has been a past conduct, that he's threatened that CAR or her family before. There's no indication that he's got some propensity for violence that would make this story any more concerning than any other story. This is, in our estimation, equivalent to the creative writing story in Douglas D, except it was never published and it was never given to anyone to read. In fact, it was in a journal that was hidden. So I think, if anything, it is more protected, more private, more and less, therefore, less likely to constitute any sort of threat under the First Amendment than the creative writing piece in Douglas D. So that's our argument there.
Okay, I think I understand, Mr. Verhoff.
It's going to talk about procedural posture in this case. Obviously, there was the original. It's been bound over, and it was on a kidnapping theory, because when police first stopped the vehicle, they found the handcuffs and the guns. After that period of time, as it's set forth in the complaint, this journal was discovered. It was written, appears to be prior to the March 30th date, or March 20th date, in which it is documented and it's discussed in the complaint how he's going to use the drugs, how he's going to use certain firearms, how he plans to go in and kill the family, sexually assault CR, as well, possibly her sister, and then he's going to have this Romeo and Juliet suicide. That, to me, Judge, is not some sort of creative writing assignment. That is someone expressing their intent of why they happen to be in that area at the time. So this isn't where somebody is just writing something to have their expressions. There are overt acts taken. And those overt acts taken are, he's in a car at the corner of their house, the intersection by their house, with the items that he has said he'd be using to commit the offense. So I don't think that the First Amendment motion succeeds as it relates to the attempt question, and whether or not there is evidence that would constitute an unequivocal act. This is discussed It's been discussed in the Stewart case, that's State versus Stewart, 143, with 2nd, 28. It's a 1988 Supreme Court case. That had to do with a variety of questions that came about after there was a robbery that was committed in a bus shelter where one individual says, give me some change or give us some change 3 to 4 times. Mr. Stewart reaches into his coat. Another individual says, put the gun away. A third person steps in and says, come on, let's go. And they leave. And the court in that case was discussing a number of factors, including what is an extraneous factor that constitutes sufficient extraneous factor, and whether or not someone could be held or be found guilty if there was an abandonment of the crime after the crime was committed, because of that context, there would exist a demand for the money. I bring this up because in the jury instructions, instruction 580, under comment number 8, there's a lengthy discussion about conduct and what goes far enough, and how the jury instruction ends, which I think suggests the answer to your question. Is this your decision to make, or is this a jury decision? And I'll just read it to you. It says, therefore, after Stewart, it is clear that once the defendant, quote, has gone far enough to constitute an attempt, a decision to end the conduct would not relieve the person of criminal liability for an attempt to commit the crime. Deciding when the attempt has really occurred will continue to be a potentially difficult factual question after Stewart, which the jury will have to resolve by reference to legal standards provided in 939(32). Do the defendant's acts demonstrate unequivocally that he intended to commit the crime? So I think ultimately the question is, I think that will be addressed, is are there acts that would demonstrate his intent to commit, in this matter, first degree sexual assaults, first degree intentional homicide, sexual assault of a child under the age of 16. I submit that the complaint sets forth that there are, but he has written about it, specifically about these people, not just kind of some theoretical person that he'd like to sexually assault, the people that he's going to kill and sexually assault. He drives his car with guns to their location. It's not a completed act. That's why it's charged as an attempt. There's an intervention. That's law enforcement pulling him over. But ultimately, the question of, okay, is that those acts, do they demonstrate unequivocally he intended to commit the crime? That's a jury instruction. That's a jury question, and it says so right in the jury instruction. So I'd ask the court to deny those motions.
All right, well, the state's alleged 6 criminal counts against the defendant, 4 for first degree intentional homicide, and 2 for attempted first degree sexual assault. In broad terms, the state is accusing the defendant of attempting to sexually assault and murder a former high school classmate, CAR, to sexually assault and murder CAR's younger sister, and to murder the rest of CAR's family, all on March 20th, 2022. The defendant has filed the 2 motions to dismiss that we've just heard argument on. The standard for a motion to dismiss in a criminal case is well known, but I'll say it. Under Wisconsin Statute 968.03, a judge has to examine the criminal complaint for probable cause to believe that an offense has been committed and that the accused committed it. A criminal complaint is a self-contained charge, which must set forth facts that are sufficient in themselves or together with reasonable inferences to which they give rise, to allow a reasonable person to conclude that a crime was probably committed and that the defendant is probably culpable. Probable cause contemplates the existence of facts and circumstances together with reasonable inferences which would incite an honest belief in a reasonable man acting under all circumstances that the charges made are true. The test under Wisconsin law for the sufficiency of the complaint is one of minimal adequacy. It's not hyper-technical, but a common sense evaluation. In the first motion to dismiss, the plaintiff asks the court to dismiss all counts against him. The defendant asks the court to dismiss all counts against him on the basis that the state has not alleged sufficient facts to support one of the elements of attempt. And that element in particular is that the defendant did acts toward the commission of the crime which demonstrate unequivocally under all of the circumstances that the defendant intended to and would have committed the crime except for the intervention of another person. To decide whether dismissal is appropriate, the court has to analyze the state's complaint allegations to determine whether they're sufficient, together with reasonable inferences, for a reasonable person to conclude that a crime was probably committed by the defendant. In its criminal complaint, the state alleges that on the evening of March 20th, 2022, the defendant drove to the 600 block of Meadow Lane in Village of DeForest. After driving through the area, the defendant allegedly parked his vehicle behind the alleged victim's residence with his lights off. The alleged victim, CAR, was on spring break from college and living at the residence on March 20th, 2022, along with the rest of her family. When police confronted the defendant, he was allegedly sitting in the driver's seat, dressed in all black, wearing a black knit winter hat and a black surgical face mask. He had his hat and face mask arranged so as only to expose his eyes and a small section of his face, allegedly. The defendant allegedly had multiple loaded 30-round rifle magazines in the rear seat of his vehicle. He also allegedly had an AR-style semi-automatic rifle in a duffel bag on the front passenger seat. When police asked him to step out of the vehicle, the defendant had a loaded magazine protruding from his pants pocket. A frisk also revealed that he was carrying on his person 6 loaded rifle magazines and 2 pairs of handcuffs. When asked what he was doing, the defendant allegedly told police he was driving around with no destination and that he was carrying all of his weapons for personal protection and that he had handcuffs in case he needed to make a citizen's arrest. The state further alleges that it subsequently recovered one of the defendant's notebooks in which he allegedly wrote, prior to the March 20th incident, a manifesto-like section titled "My Mission, Savage." And in this section, he allegedly begins, "You must all be wondering why I did this. Well, I'll tell you why." And he allegedly goes on to describe in writing the alleged victim, CAR, and his interactions with her. He allegedly notes that he found CAR's address in the white pages following a death in her family. And toward the end, he allegedly writes, "So my plan is to go to CAR's house," followed by details about his intention to shoot and kill CAR's family, to commit sexual assaults of CAR and her younger sister, and then to kill himself alongside CAR. The journal allegedly contains details about how and where the defendant wanted to be buried and instructions to let his journal be made public. Under Wisconsin Statute 939.32 sub 3, the requirements for an attempted crime are set forward. It states that an attempt to commit a crime requires 1, the actor have an intent to perform acts and attain a result which, if accomplished, would constitute such a crime. And 2, the actor does acts toward the commission of the crime which demonstrate unequivocally under all circumstances that the actor formed the intent and would commit the crime except for the intervention of another person or some other extraneous factor. Here the court concludes that the state has alleged sufficient facts, together with reasonable inferences, to survive a motion to dismiss the charged attempted offenses. First, the state has alleged sufficient facts to show that the defendant had an intent to murder CAR and her family, as well as to commit sexual assault of CAR and her younger sister. The complaint details the contents of the notebook I just mentioned, in which the defendant allegedly set forth a plan to go to CAR's house and to commit those offenses. The complaint alleges that the notebook was found in the defendant's car, contained the defendant's name, and had the defendant's handwriting. This is enough to satisfy the intent element of attempt, at least for purposes of a motion to dismiss. Second, the state has also alleged sufficient facts to show that the defendant took acts toward the commission of the crime, which demonstrated unequivocally, under all circumstances, that he had formed the intent and would commit the crime except for intervention of another person. I've also looked at the State versus Stewart case that was mentioned by the state, and there the Wisconsin Supreme Court explains that this component of attempt requires that, quote, the accused has committed sufficient acts that it is unlikely that he would have voluntarily desisted from the commission of the crime. Here, the state has alleged that the defendant found CAR's home address in the white pages. He then drove to her home in Sun Prairie on a day in which she just happened to be home from college on spring break, and the rest of the family was also home getting ready for work and school the next day. Again, all alleged facts. The defendant allegedly parked outside the house at night with his lights off. He allegedly dressed himself in all black attire, from which the court can reasonably infer an intent to camouflage his appearance. He allegedly obscured his face with a black cap and black surgical mask. And finally, he armed himself heavily with rifles and ammunition, as well as 2 pairs of handcuffs. Viewing these facts under all circumstances and taking all reasonable inferences in favor of the state, the court concludes that a reasonable person could reach the conclusion that the defendant's actions on the evening of March 20th, 2022, demonstrate that he would have committed the murders and sexual assaults if not for police intervention. In other words, a reasonable person could conclude that the defendant had committed sufficient alleged acts by the time police found him that it's unlikely he would have voluntarily desisted from committing the crimes. The fact that law enforcement did not immediately charge the defendant is irrelevant, since they could not at the time have understood his intentions until they did further investigation and discovered his notebooks and writings. So the court's going to deny the first motion to dismiss. In the second motion to dismiss, the plaintiff asks the court to dismiss all counts against him on the basis of an as-applied challenge to the constitutionality of the attempt statute under the alleged facts. He argues that the state is criminalizing his speech by using the writings contained in his private journal to form the basis for its charges. According to the defendant, the content of First Amendment protected speech alone is insufficient to form the basis for criminal conduct. The court finds no merit to this theory of dismissal. The state has not charged the defendant with a crime for allegedly writing his unsettling thoughts down in a journal. Instead, the state has charged him with attempting to murder and sexually assault CAR and her family. It's merely relying on the defendant's journal writings as evidence of his intent to commit those crimes. Recall that one of the elements of an attempted crime is that the defendant have an intent to perform acts and attain a result which, if accomplished, would constitute such a crime. The criminal jury instruction for attempt, which is jury instruction 580, explains that intent must be found, if found at all, from the defendant's acts, words, and statements, if any. Here, the defendant's own alleged words written in his journal are evidence of his intentions. They are not criminal standing alone of an evidentiary puzzle. If the court were to adopt the defendant's interpretation, the First Amendment would prohibit the state from ever relying on any public or private statement made by any defendant concerning a charged offense as evidence of intent. For those reasons, taking all reasonable inferences in favor of the state, the court finds no basis to dismiss the state's claims under the First Amendment or jurisdictional grounds, and will deny the second motion to dismiss.
Thank you, Your Honor.
Thank you. Now, let's turn to the prelim. Is it going to be a go?
Yes.
Okay. How many witnesses for the state?
I have 1 witness.
Who's that?
It is Detective Benjamin Larson.
Okay, detective, if you're in the courtroom, come forward.
And Judge, before we start testimony, I'm going to ask that counts 1 through 6 be determined to be transactionally related.
This is the cop that pulled him over?
Yeah.
But not necessarily.
Based on the alleged facts for our finding of transactional relations, so that's
So that cop was just in the right place at the right time. Oh, someone called. Okay, okay.
Settled in, if you could start by stating your name, title, and you.
Benjamin Larson. I'm a detective for the Village of DeForest Police Department.
Okay. Mr. Verhoeven.
And just for the record, can you spell your first and last name for us?
BenjaminLarson.
Detective, I'm going to ask you if, in your course of the employment with the DeForest Police Department, did you have the opportunity to be assigned to an investigation involving an individual identified as Gabriel Savage?
I did.
And when were you assigned to do that?
In March 2022, approximately March 21st.
If you saw the individual Gabriel Savage in court today, to whom these investigation relates, do you think you'd recognize him?
I would.
Can you take a look around the courtroom and you see if you recognize the individual you investigated, identified as Gabriel Savage?
Yes, he's sitting at the defendant's table wearing the Dane County Jail uniform.
And ask the record to reflect the in-court identification of the defendant.
Any objection?
He's sitting at council table in jail clothes, so no.
The record will reflect the identification.
All right, Detective, you indicated that you became involved in this investigation around March 21st. Was there an incident that occurred on March 20th, 2022 involving Mr. Savage?
Yes, on that date, approximately 9:59 p.m., DeForest officers were dispatched to the 300 block of Meadow Lane in the village of DeForest, Dane County, Wisconsin, for a suspicious vehicle complaint. It was reported that a vehicle had driven through the area and then was parked on the wrong side of the road with its lights off.
And to your knowledge, did officers from the DeForest Police Department make contact with that vehicle?
Yes, they did. 2 officers made contact with the vehicle.
And what's your understanding of what occurred?
So they made contact with the silver Hyundai Sonata with a Wisconsin registration plate ending in 4102. Officers made contact with the single occupant of the vehicle who was sitting in the driver's seat. Upon contact, one of the officers had observed multiple 30-round loaded magazines in the rear seat of the vehicle. The same officer also observed the barrel and muzzle of an AR-style semi-automatic weapon, which was in a duffel bag in the front passenger seat of that vehicle. The officers then asked the subject who was seated in the driver's seat to exit the vehicle, where they observed another loaded 30-round magazine and conducted a pat-down of him, where it was located 6 total 30-round magazines, which had ammunition in them. There was also 2 handcuff sets located on the driver.
When you indicated that they stopped this sole occupant, Gabriel Savage, is that the same individual that you identified in court earlier today?
It is.
And I think you said so, but I just want to make sure because you were speaking a little quickly. Meadow Lane, is that located in the village of DeForest, Dane County, Wisconsin?
It is.
Okay. In addition to the magazines and firearms in handcuffs, did the officers make any observation, to your knowledge, about how Mr. Savage was dressed that evening?
They noted that he was dressed in all black, had a black winter knit hat on that was pulled low, as well as a black face mask. They noted that they could only observe the defendant's eyes at that time and a small part of his face.
And did he indicate to officers what he was doing there in the area?
The officers noted that the defendant had said he was just driving around with no destination. He mentioned that he had the firearm and ammunition for personal protection, and the handcuffs he had were for in case he had to make a citizen's arrest. The defendant also appeared to be slow and lethargic when responding to the officer's directions at that time.
And from your investigation, did the officers at that point, or did you later have a reason to suspect he might have been under the influence of some sort of drug?
They did that night of.
Now, this all that you've testified to occurred on March 20th, 2022. When you became involved on the 21st, what was your role? What did you do as the detective in this case?
We began looking at the case and the specific details of what information we had at the time, trying to determine if there was a correlation between where the defendant was parked and then any reason or notion that he was parked in that area, to try to determine if there was a certain location that he was parked there by. So we were looking into that.
Okay, and were you able to make any conclusions or find any information that assisted you in your investigation to make a determination why he might have been in that area?
Yes, on a few days later, on March 25th, the defendant's parents came in with a notebook that they had found within the vehicle. within the vehicle, or excuse me, within that notebook, the parents both said that the handwriting in the notebook was the defendant's. They were positive that. They wanted to bring the notebook to police as they had concerns about some of the writing that they had found within the small notebook in the vehicle.
And when you're talking about the vehicle, is this the same vehicle that officer had stopped Mr. Savage in on the 20th on or near Meadow?
Correct, yeah, the vehicles was registered at the time to both the defendant and his mother.
Okay, and so with that information, that there's some writings that his parents had found in the video, or excuse me, the vehicle, what did you do with that information?
I looked through the notebook. The parents did have concerns, as they had mentioned to me, that there was writings about how to operate a rifle. There was writings about taking his prescription medication in a way that's not prescribed, as well as they had noted to me that there was a female's name written in the notebook with her address, which was very near to where the defendant was found parked. The defendant's mother had informed me that she was aware that her son had an infatuation with a female by that first name, but was unsure of who she was.
And the female, is that someone who has been identified in the complaint as CAR?
It is.
And did you make any attempts to determine where CAR or family may have been living at the time as it relates to the location of Mr. Savage's vehicle when he was stopped?
Yeah, on March 29th, another DeForest police officer, Officer Castola, went to the residence, made contact with the resident there, who confirmed that there was a female subject who lived at that residence address that has the initials CAR.
And at any time, did you have the opportunity to meet with CAR?
I did.
What was your purpose of meeting with CAR?
I met with CAR on April 1st, 2022, just to speak with her about any involvement that she had with the defendant at the time, just to try to determine if she was aware of who he was or if she had any sort of relationship with him, to try to find out why he was parked outside of her residence.
And what were you able to find out? What did she tell you?
While speaking with her, she informed me that she was aware of the defendant. She indicated to me that she had been in school with him since 7th grade. When she moved to DeForest, she told me that the defendant was somebody that she tried to avoid, that she had minimal interactions with, and noted that she believed she only had 2 direct contacts with the defendant throughout their time in school together from 7th grade throughout high school. CAR was very, very stressed about the situation. She was unsure of why the defendant would have any kind of infatuation with her, as she didn't have a relationship with him at all. She was very fearful and very scared of what may have happened, or scared for her family and herself.
Now, this residence on Meadow Lane, where CAR lived, is that her home address? In other words, is she living there year-round right now, or is she living someplace else?
That's her primary residence, but at the time, on March 20th, she was home from college on spring break, so she was at that residence.
And do you know if there were other people from CAR's family who were living at the residence on Meadow?
Yes, she has a younger brother and a younger sister who also reside at that address with their grandmother, so 4 total residents within that house.
Okay. After speaking with CAR about where the investigation was at that point, was that the end of your investigation, or did you continue to look into the situation?
The investigation continued, and still is, right.
When around April 2nd, were you able to review some other notes that Mr. Savage had prepared?
Yes, after the execution of a search warrant at the defendant's residence, there were numerous post-it notes located under his bed. From reviewing those, I did locate one post-it note that had a time on it, as well as CAR's first name, and referenced checking CAR's Facebook profile for motivation.
And was there anything else that you noted about his infatuation or his connection to CAR?
In the post-it notes?
Yeah.
Is that what you're referencing? There were some references in there about being bullied, and had CAR's name written down, which was crossed out in one of the other post-it notes.
And was there anything indicated in your investigation that sometimes that CAR had been particularly nice to him?
Yes, it was from reading multiple documents. It's been found that there was 2 alleged incidents where they had that direct contact where CAR was friendly with the defendant.
And based on your discussion with CAR and your investigation, would that have been in reference to time they were in high school or younger ages together?
Correct, I understand it to be high school age.
Now, you indicated that the investigation continues to be ongoing. Did your agency come into some information in June, specifically on June 20th, regarding this case that you found to be interesting?
Yes, on June 20th, I made contact with CAR's younger brother. He met me at the police department with his grandmother and wished to provide some information about a Discord chat group that he has had with multiple people for multiple years. He informed me, CAR's younger brother informed me that the defendant's younger brother is also involved in this Discord chat group. CAR's younger brother informed me that on the morning of June 20th, when I met with him, that the defendant's younger brother had sent a group message trying to get in touch with a female by the initials TP. It was CAR's younger brother allowed me to look at those messages on Discord, where CAR's younger brother identified the defendant's younger brother as being the one who sent the messages, as the profile picture matched the defendant's younger brother, as well as the username had matched some of the online gaming systems that they use. So the defendant's younger brother had sent this message out asking for help to try to locate this female with the initials TP. The defendant's younger brother had noted that the defendant had made mention to killing a female in her family. He had wrote that his brother had bailed out from jail and that his brother was trying to buy mace. Some of the conversation had asked about this additional notebook that the defendant's younger brother referenced. At that time, the defendant's younger brother made a note and sent a message that he didn't have the notebook, that the defendant's parents had the notebook, and wrote that the defendant's parents weren't going to turn it over to police.
And with that information, did you, or as part of this investigation, then make attempts to obtain this other notebook that you became aware of on June 20th?
We did. We had coordinated with two other agencies, as the female with the initials TP had resided in Sun Prairie. So with the initial information that this other female was possibly a target, we involved the Sun Prairie Police Department at that time through coordination with Sun Prairie Police, as well as the Wisconsin Dells Police Department. On June 20th, it was determined that the Wisconsin Dells Police Department detective would travel to the defendant's parents' residence in Wisconsin Dells in attempts to retrieve the notebook that they had found.
And did law enforcement obtain that notebook?
They did.
And have you had an opportunity to obtain Mr. Savage's notebook that was provided by his parents?
Yes.
And is there anything of interest in there to you as it relates to this investigation?
Yes, through reviewing the notebook that was found, it was reported from the Wisconsin Dells Police Department detective that the defendant's mother had provided the notebook to the Wisconsin Dells detective and was informed at that time at the defendant's parents' house that the notebook was found in the defendant's vehicle under the driver's seat as they were cleaning it out in preparation to sell the vehicle. From reviewing the notebook, it's a blue notebook with the defendant's name, Gabe Savage, written twice on the front cover. The notebook itself is 100 pages, composition notebook with almost the entirety of the notebook filled. The major first portion of the notebook is almost like a daily journal with dates written and then obviously journalings suspected to be from the defendant. Towards the end of the notebook, the last journal entry dated is September 30th, 2021, and then it goes into multiple pages that are not dated. With those pages at the end of the notebook that are not dated, it's believed to be that the defendant had wrote his manifesto there with titling it "My Mission Savage."
Let me stop you right there for a second. You've had the opportunity to review the previous information that his parents had turned over that they indicated was in his handwriting, in Mr. Savage's handwriting. Have you had the opportunity to review that as part of your investigation?
I have.
And then you've had an opportunity to look at the journal here, this document that was obtained by law enforcement. Did you have an opportunity to compare the handwriting in this journal to the other documents that have been provided to you that are purported to contain Mr. Savage's handwriting?
In my opinion, the handwriting is from the same individual.
And fair to say, you're not a handwriting expert,
Right.
so you're just observing the two side by side.
Correct.
Okay. Now, you indicated there was some sort of a manifesto titled My Mission Savage. Was there information in what you described as a manifesto that references CAR and or her family?
Yes, in the writing it does list CAR's first and last name.
And does it list in the manifesto any intentions or what Mr. Savage was planning or thought to do as it relates to CAR and her family?
Yes, it's multiple pages where it kind of goes into the defendant's belief that CAR had a crush on him. As the manifesto writes, it writes about details about their interactions together, and it does reference a plan to go to CAR's residence, kill her family, rape CAR, rape CAR's 14-year-old sister, and then kill himself in what he references like Romeo and Juliet.
In that document, is there any indication as to efforts that Mr. Savage went to determine her location, CR's address or location?
Yes, it details how the defendant had utilized white pages to use the obituary of CAR's deceased father to locate her mother's name and then utilize white pages to locate her address.
And is that address the address on Meadow? I was calling it Meadow View? Meadow Lane, sorry.
Meadow Lane, correct.
All right. And did he indicate where he was going to kill in this document? Did he indicate where he was going to go kill CAR and or her family?
He referenced going to CAR's, going to her residence, and then proceeding to make contact at the residence, kill her family, rape her, rape the sister, and then kill himself while holding her hand.
Did he indicate in there at all anything regarding the type of ammunition specifically he would use for this?
Yes, he referenced that he would kill the family with 5.56 FMJ, which is full metal jacket ammunition, and then referenced that he would shoot himself with 2.23 caliber soft point ammunition.
Now, was this information significant to you as it relates to the investigation as a whole?
It is on the search warrant that was executed on March 31st, 2020. There was both 5.56 full metal jacket ammunition and .223 soft point ammunition seized from the defendant's residence.
I have nothing further.
Ms. Kinnear? Any cross?
Yes, Your Honor. Detective, you indicated on direct that you and DeForest Police initially became aware of this situation when it received a phone call that a car had driven through the area and was now parked, I think, with its lights off, is what you testified to. Do I have that right?
Yeah, I believe so.
Did the caller indicate how long the car had been there?
Not that I recall.
But the call did indicate that the car was on a street, right?
Correct.
Not a driveway.
Correct.
Did the caller indicate whether the driver was in or outside of the car?
I don't know that. I didn't speak with the caller, the initial call.
You haven't listened to the recording of the dispatch?
Direction relevance.
Do you know if the car was on or off?
I don't.
Relevance.
Keith?
I'll overrule that objection. Go ahead.
Thank you. I'm sorry. Do you know if the car was on or off?
I do not.
When the officer approached the car, though, based on what you've reviewed of reports, the defendant was sitting in the driver's seat, is that right?
That's my understanding.
He was not out of the car when they approached, right?
Correct.
Do you know if keys were in the ignition?
I do not.
Did your officer observe whether the car was on or off during the stop?
I don't know. I don't know.
He did observe, I think you said, a duffel bag with a muzzle sticking out?
Correct.
Okay, and so if the muzzle's sticking out, that means the handle of the gun was inside the duffel bag, right?
As long as I'm picturing a duffel bag, but from
Do you know?
I don't know.
Okay. Was the defendant's hand on the gun?
Objection relevance.
I'll overrule that objection for now. Go ahead.
I don't know.
Then at some point, the defendant gets asked to step out of, the driver gets asked to step out of the vehicle, you testified, and he was frisked, right?
Correct.
And there was ammunition found on him, right?
Correct.
And handcuffs,
Correct.
but no guns,
Correct.
no knives.
I'm not aware of any.
But that's probably something that would make it into the report, right?
I would hope so.
Okay. And ultimately, the driver was arrested, right?
Correct.
On suspicion of an OWI?
Correct.
After his arrest, did your officers impound the vehicle?
Objection relevant.
Sustained.
Was the vehicle searched?
No, not by police. Well,
Not at that time, right?
the initial officers, from my understanding, did do an initial sweep for firearms and ammunition,
Okay.
which is how they had the ability to remove the rifle from the vehicle and from the ammunition from the rest of the vehicle.
Okay. But it was a sweep, so you mentioned like 5 days later, the parents brought in a notebook or some, like a Post-it pad or something, right?
Yeah, yellow Staples notebook, so a smaller, not a full sheet of paper, but a smaller notebook.
Like a legal pad?
Nope, smaller than that.
Okay. That wasn't found during the sweep, right?
Objection relevant.
What's the relevance?
My apologies, Your
No,
Honor.
it's okay. If there's relevance to the scope of the inquiry, I'm happy to hear it, but otherwise I have to sustain the objection.
That's fine, Judge.
Okay.
So you said you were assigned the case on March 21.
Well, the call came in March 20th at 10 in the morning, or about 10 o'clock at night. I wasn't on duty at the time, so it's common that the next morning I will be briefed and review the briefing logs and stuff from the incidents from the night before. So the following morning, I'm informed of the investigations or incidents that happened that night when I'm not on duty.
Were you normally assigned OWI 1s?
Objection relevant. Sustained.
Okay, so you're assigned the 21st, March 25, the parents bring in the notebook, right?
Correct.
That's 4 days later. Yes?
Correct.
You had an opportunity to review the writings in the notebook, right?
Could you clarify which notebook?
I'm sorry, the one that the parents brought in 5 days after the OWI stop?
Correct.
And those writings, at that time that you reviewed it, which presumably was on or about March 25, right?
Correct.
Those writings were the ones that talked about medication, yes,
Correct.
weapons.
Operating the rifle, correct?
And this is the one that had an entry with CAR's name and address.
Correct.
So then, 4 days after that, on March 29, you reach out to CAR and her family, right?
Not myself personally, but another DeForest officer.
Oh, you delegated.
Correct.
And then March 31 is when the search warrant is executed at the apartment?
Correct.
That's 11 days after the OWI arrest.
Is that an objection? That's not a question, it's a narrative.
I will.
Ms. Kuna, are you trying to indicate that the state didn't investigate this as if it was as urgent of a case as they're now claiming?
Indeed, Your Honor.
What's the relevance of that?
Your Honor, I think it goes again to whether or not the act was equivocal, right? There was an alternate inference that was accepted by law enforcement at the time, and
But just if there's some other reasonable inference that doesn't make, as long as there is a reasonable inference, the fact that there's another different also reasonable inference doesn't, I'm not here to weigh those inferences. So I guess I'll sustain the state's objection on that ground, and if you're going down that road, I'm probably going to continue to sustain those objections unless you have a different focal point in mind.
that was my last question on that point, Judge.
Okay, go ahead then.
Based on your investigation, Detective, the initial call that there was a car parked on the street with the lights off. That did not come from CAR's family, right?
Correct.
And I'm sorry because I'm confused. I think you testified on direct that you spoke with CAR directly.
I did.
Okay. When did you do that?
April 1st.
April 1st, okay. And when you spoke with CAR directly, she talked about two, perhaps, maybe two, minimal interactions she'd had with the defendant, right?
Direct contact with the defendant, correct.
Okay, and this was presumably some time ago, right? You said they were in high school at the time that these interactions took place?
Correct, the two interactions during high school.
Okay. So the record is clear. Then the allegation isn't that the defendant came to the door that night of March 20, right?
Correct.
And CAR didn't indicate she'd seen him outside her window, right?
Correct.
In fact, CAR wasn't even aware the car was parked outside that night, right?
Objection to relevance.
Sustained.
Did CAR indicate whether she'd received any phone calls from the defendant in and around March 20?
No.
Any texts?
Object to relevance on the line.
I'll sustain the objection.
You also had the opportunity to speak with other members of CAR's family?
Correct.
Did anyone else indicate they were aware of the defendant?
Objection to relevance.
Okay.
I'll go ahead and answer that question.
Could you repeat?
Did anyone else in the family indicate they'd had any contact with the defendant?
No.
Had they ever seen him before?
I'm not sure. I don't know.
And based on your review and your investigation, have there been any previous contacts involving either Mr. Savage or the Hyundai in and around Meadow Lane?
Could you repeat?
Based on your investigation, are you aware of any previous contacts with Mr. Savage or the Hyundai in and around Meadow Lane prior to March 20?
Not confirmed.
Okay. Meaning not investigated?
Has to be answered.
That's fine. Okay, so then we flash forward, what is that, almost 3 months after the OWI stopped to June 20, you become aware of this journal, yes?
Yeah, correct.
And this was not found during the sweep your guys did on March 20, right?
Correct.
Ms. Kuna, I'm going to have to start imposing some time limit here.
My apologies, Judge. I'm just
You know, I want you to get in your record, but we're also approaching 4 o'clock and there's a lot of prelims.
My goodness, okay. Do you have any idea how long the journal had been in the car?
No.
And you said that the majority of the journal was a daily journal, meaning that it logged things other than what you've termed as a manifesto?
Correct, almost daily.
Almost daily,
Almost
okay.
daily.
So basically the whole journal was full, right?
The entire notebook was almost almost completely filled with handwriting. I would say 3/4 of it were the daily journal or almost daily journal with the dates and writings about what occurred or what the defendant was writing about for that day.
And the writing that was concerning to you, you said was undated,
Correct.
but the entry before was September 30, 2021.
Correct.
So about 6 months before the car was on the street outside.
Objection form. It's not a question.
I can tell that it's 6 months. Go ahead with your next question.
In the journal, was there any information, because, I'm sorry, let me back up. You indicated on the record that they were in high school together, but now CAR was in college, right?
Correct.
And CAR was in college, not in DeForest, right?
Correct.
Somewhere else.
Correct.
Okay. Was there any information about, that you observed in the journal about where CAR went to school?
Objection, relevance.
Any information as to when CAR would be on spring break?
Objection, relevance.
Go ahead and answer that.
Not that I found.
Any information about the comings and goings of this 14-year-old sister?
No.
And you said the story describes, I think you said a 5.56 FMJ ammunition and a 2.23 soft point ammunition.
Yeah, I will correct myself. .223 is the caliber. I said it incorrectly the first time, but .223
223.
soft point.
Okay, I may have said it wrong too. And you said that those items were found in the apartment,
Both types of ammunition were found in the apartment.
but not the car.
I don't know yet.
I think that's all I have.
Any redirect?
No, sir.
Thank you very much for your time, Detective. Any other witnesses for the state?
No, sir.
Does the defense intend to proffer evidence?
No, Your Honor.
State has a motion.
I move for bind over waive argument.
Any argument from the defense?
Object to bind over. I will also waive argument.
All right, based on the evidence, I find there's probable cause to believe that a felony has been committed by this defendant, and therefore I bind this matter over for further proceedings in branch 13 before Judge Genovese. Bail conditions will continue as previously set. Has the defense had an opportunity to see the information?
I just e-filed the information and I need to send it to Attorney Kuna. It does track.
Ms. Kuna, are you prepared to go forward with an arraignment?
I'm not, Your Honor.
Is there a reason?
Your Honor, I need to have a conversation with my client about his right to substitution.
Okay. Do you want to do that right now? Or
Your Honor, given my client's developmental disabilities, I prefer to have a longer private conversation.
all right, in light of that, we'll put off the arraignment. That'll be scheduled in branch. Anything else to take up today? I'll start with you, Mr. Burrow.
No, thank you, Judge.
For the defense?
No, Your Honor, thank you.
Okay, thanks everyone. We're adjourned.